I ask leave of the House to move amendments 1 to 3 on the sheet revised 2nd July 2024 as circulated in my name together.
Is leave granted? The Minister for the Environment and Water.
Leave is granted.
Member for Wentworth may proceed.
I move amendments 1 to 3 on the sheet revised 2nd July 2024 as circulated in my name together. Speaker, the creation of the Environmental Protection Australia is an important step in the right direction. There are many welcome changes within the package of bills before the House, but there are also significant issues that need to be fixed. These issues go to transparency, accountability, independence with which the new EPA will operate, and they should be addressed before the bills proceed to the Senate. The House should be a place where legislation is improved, not just rubber-stamped. Speaker, one of the main reasons for having an EPA is to take important environmental decisions out of the hands of politicians. We want to have independent experts assess projects in an unbiased and even-handed way, free from political interference and lobbying by special interests. This independence must be at the core of the new EPA. Now, I accept that, in some special cases, the Minister should retain the prerogative to make a particular decision. The Minister and the Government are the only ones who ultimately are accountable to the Australian people. And so it is appropriate that the Minister retains the right to call in a particular project, which she may have previously delegated to the independent EPA. However, what is not appropriate is for the Minister to call in a project and for them not to tell the Australian people that they have done so. If the Minister wants to make a captain's calls, they need to be upfront about it. And unfortunately, this transparency is not provided for in the bill. The bill allows the Minister to delegate certain functions to the EPA, but there is no requirement for the details of that delegation to be made public. As a result, we may have no idea which types of decisions will be delegated to the EPA and which ones the Minister will keep for themselves. This is despite extensive consultation on ministerial call-in powers over the past year and clear feedback from a range of stakeholders about the need for transparency over what is delegated to the EPA and what is not. Unfortunately, this lack of transparency creates the risk that environmental approvals will be shrouded in the same secrecy as the flawed system of the past. My amendments would address this lack of transparency. Amendments 1 and 2 require that the instruments of delegation are made public so that we know which decisions the Minister is handling over the EPA and which the Minister is designating for themselves. These amendments are constructive and common sense and respond to feedback provided by the environmental community, by the business community and by experts in environmental law. They do not place an unnecessary burden on the government. They merely require transparency on things that the public have a right to know. My team and I have worked constructively with the Minister on these amendments, but it is disappointing, therefore, that the government has decided not to support them. I understand the government no longer believe it is necessary to make the changes set out in my amendments because they already intend to provide similar level of transparency. If this is the case, there should be no issue in providing for this transparency in the legislation. There should certainly be no problem in committing to make the instruments of delegation publicly available. And whilst I take the Minister at her word, and I know that she wants to do the right thing, she cannot guarantee that all future ministers would act with the same degree of integrity. These transparency measures should be included in the legislation, and so I urge the government to accept the amendments.